Good evening. I call to order this work session of the Knox County Commission for February 15th, 2022. Madam Clerk, would you please call the roll?
Commissioner Lundy,
Here.
Commissioner Durrett. Here. Commissioner Smith,
Here.
Commissioner Ward,
Here.
Commissioner Schoonmaker,
Here.
Commissioner Hill, Commissioner Bustler,
Here.
Commissioner Beeler,
Here.
Commissioner Daly,
Here.
Commissioner Jay,
Here.
Commissioner Biggs.
Thank you, Madam Clerk. Commissioner Smith, would you please lead us in the Pledge of Allegiance?
Thank you, Mr. Chairman. Tonight we have with us some fine young men from Boy Scout Troop 757 to lead us in our pledge tonight. Gentlemen, if y'all come on up stage. And my colleagues, they have requested a photo with full commission after they're done, so if you would join me out there after we finish.
Good job. All right, there's going to be a photo op.
This way. Very, shoulder to shoulder. On the line, on the line. Take it up.
Say fromage. Nice. Thank you. Good job, boys. Thank you. Good job, guys. Take care, okay? Don't you? I'm John. Thank you. Appreciate it. Probably. Yeah. Good job.
Commissioners, thank you, gentlemen, by the way, for leading us in the pledge. Commissioners, here is at the pleasure of the body how tonight's meeting will flow. After we set the agenda, I believe all of our presentations are scheduled for next week. I'll look to my colleagues to make sure that's correct. I don't believe any of our presentations, Mr. Odom or Mr. Bagwell, are for tonight. They'll be for next week's regular commission meeting. Then we will get into the remainder of our agenda. There are actually a total of 6 additions to the agenda now. Those are items 23, 37, 38, 41, and then there are 2 copies of resolutions that are late additions that each of the commissioners has been given. We have 2 deferrals. Item 2, which is an honorary resolution, is being deferred. Is that to next month, Commissioner Bustler? Okay. And item 42 is also being deferred. The one withdrawal, item 50, is actually a zoning item. The non-consent items, items 1 through 11, item 16, item 23, item 37, 38, 40, and then the 2 late additions as well. That's items 1 through 11, 16, 23, 37, 38, and 40. Chair will entertain a motion.
Motion to approve?
Second.
I have a motion to set the agenda by Commissioner Smith with a second by Commissioner Schoonmaker. Is there any discussion? All in favor, please say aye.
Aye.
Any opposed? Agenda is set. Madam Clerk. Thank you. First item.
This is under honorary resolutions. Resolution R-22-2-101 is a resolution honoring Mr. Mike Walls for his role in rescuing two persons from a burning home on January the 23rd, 2022.
Second.
Motion to send forward with no recommendation by Commissioner Daly with a second by Commissioner Hill. Any discussion? Commissioner Daly, did you want to? Oh,
Let's switch that, I apologize.
okay. All in favor, please say aye.
Aye.
Any opposed? Motion carries. Madam Clerk, next item, please.
Page 2. Approval of minutes of the previous meeting.
Second.
Motion to approve the minutes by Commissioner Bustler with a second by Commissioner Hill. Any discussion? All in favor, please say aye.
Aye.
Any opposed? Minutes are approved.
Drives and roads. Consideration of the acceptance of new county roads.
Motion to move forward without recommendation.
Motion to move forward with no recommendations by Commissioner Hill with a second by Commissioner Bustler. All those in favor?
Aye.
Any opposed? Motion carries.
Item number 7, consideration of the closure of the unbuilt portion of Chirping Bird Lane east of Creekside Manor Lane in Creekside Manor subdivision. This is on second reading.
Second.
I have a motion by Commissioner Biggs, second by Commissioner Hill. All those in favor, please say aye.
Hold,
I'm sorry.
We
Commissioner-
should send this no recommendation since it's.
Oh, I'm
Yes.
sorry. I misheard. I thought that's what we were doing. Is you willing to change your motion? Motion is to send forward with no recommendation by Commissioner Biggs, second by Commissioner Hill. All those in favor, please say aye.
aye.
Any opposed? That motion carries.
Item number 8 is line item transfers.
Motion to move forward with no recommendation.
I have a motion to move forward with no recommendation by Commissioner Schoonmaker with a second by Commissioner Bustler. Any discussion on line item transfers? All those in favor, please say aye.
Aye.
Any opposed? That motion carries.
Item number 9 is budget amendments in the amount of $2,084,030.73.
Motion to move forward with no recommendation.
Motion by Commissioner Schoonmaker, a second by Commissioner Bustler to move forward with no recommendation. Any discussion? All in favor, please say aye.
Aye.
Any opposed? That carries.
Item 10 is spread of record of the Knox County Sheriff's appointment of Captain Greg Stennett to serve a non-voting liaison to the Knox County Ethics Committee. Number 11 is spread of record, the District Attorney General's appointment of Robin Jones to complete the unfulfilled term of Nate Ogle on the Knox County Employee Insurance Benefit Committee, which term expires December 31st, 2023.
Thank you, Madam Clerk. I believe we now move to item 16.
Page 4. Consideration of a resolution approving an agreement with Skilled Services Qualities Construction LLC for the Halls High School exterior upgrades project in the amount of $2,494,000, Resolution 205.
I have a motion to approve by Commissioner Bustler. Is there a second? Second by Commissioner Biggs. I actually pulled this. Thank you, Mr. Oakes, for being here. I just was curious as to what exactly we were doing at Halls High School.
This is one we've been working on for about 18 months to get properly scoped. And this started out because we just wanted to clean up the facade of Halls High School and make it look nice after 55 years of not much. And as we got into it, we found that there was some deterioration in some of the aggregate concrete that had been used, and there was deterioration and some stucco that we couldn't easily repair, and that we also had water intrusion in some of the windows. So as we finally got this thing scoped and got a contract bid, we're going to replace all the windows in the building, and then we're going to go through and do a metal cladding over the deteriorating stucco and the deteriorating aggregate concrete work.
Thank you, Mr. Oakes. Commissioner Biggs?
Thank you, Chairman Beeler. Mr. Oakes, does this also encompass the locker bay with the plywood over it when you walk in as well?
It's my understanding that our maintenance department's already done that work, and
Okay.
it's complete.
Thank you.
Any further discussion? All those in favor, please say aye. Any opposed? That item carries. Madam Clerk, next item, please.
On page 5, item number 23 is a resolution approving a contract with Donald S. Gable, M.D., in the amount of $121,500 to perform the services of medical director for the Knox County Sheriff's Office Corrections Division and to provide pre-employment fiscals to potential candidates for employment for a one-year term beginning January the 1st, 2022, and ending December 31st, 2022, with 2 additional annual renewals for a total of 3 years. Resolution 302.
Motion to approve.
Have a motion to approve by Commissioner Biggs, second is by Commissioner Daley. Is there any discussion? It was added. All in favor, please say aye. Aye. Any opposed? Motion's approved. Madam Clerk?
On page 7, item number 37. This is a resolution of the Commission of Knox County, Tennessee regarding the assurance of not to exceed $37,040,000 general obligation bonds for Knox County, Tennessee, Resolution 805.
Motion to move forward with no recommendation.
Have a motion to move forward with no recommendation by Commissioner Schoonmaker, second by Commissioner Bustler. Is there any discussion? All those in favor, please say aye. Aye. Any opposed? That item moves forward. Madam Clerk, next item, please.
Item number 38 is a resolution authorizing the assurance of general obligation bonds for Knox County, Tennessee, in the aggregate principal amount of not to exceed $87,040,000 in one or more series, making provision for the assurance, sale, and payment of said bonds, establishing the terms thereof and the disposition of proceeds therefrom, and providing for the levy of taxes for the payment of principal, of premium, if any, and interest on the bonds. This is Resolution 806.
Motion to move forward with no recommendation.
Motion to move forward with no recommendation by Commissioner Schoonmaker, second by Commissioner Bustler. Commissioner Schoonmaker, you have the floor, sir.
Thank you. Unless the Finance Department wants to weigh in, but just so for those folks who are watching this broadcast know that this is going, $58 million and change is going to, for Knox County schools, and about, $18 million is going to engineering and public works for road projects. So just so people know that, and this was already approved back last spring.
Very good. Any further discussion? All in favor of sending forward with no recommendation, please say aye. Aye. Any opposed? That item moves forward. Madam Clerk, item 40, please.
Consideration of an ordinance of the Commission of Knox County, Tennessee, amending Knox County Code Appendix A zoning to reflect the name change of the Knox County Planning Commission by removing metropolitan from the name throughout the Appendix A. This is ordinance number O-90-9-130, adopted September 10, 1990, as amended. This is ordinance number O-22-2-101.
Chair will entertain a motion. Have a motion to move forward because it's an ordinance by Commissioner Jay. Is there a second? Second. Second by Commissioner Ward. All in favor of moving this forward with no recommendation, please say aye. Aye. Any opposed? That item moves forward for first reading, and I will remind commissioners that if this passes on first reading next week, we will have to set a public hearing before passing it on second. Madam Clerk, we're now to public forum, and I actually noticed we have 3 individuals signed up for public forum, all to speak to the same issue, which at the time they signed up was not on the agenda. It is now, but we will now hear these 3 folks since this item is coming up either next or just after that. First, we have Ms. Angie Gothard. If you'll state your name and county of residence, ma'am, you have 5 minutes to address commission.
Thank you. My name is Angie Gerthert, and I'm a Knox County resident. I honestly did not believe I would ever be back here speaking on behalf of children and parents about masks, but here we are. September 24th, 2021 is the date that normal was taken from our children in our schools, many teachers and parents. A lawsuit filed against the BOE where the injunction put in place hurt those that had no defense at all. How does that happen? We elect officials to serve us, the voters and taxpayers of Knox County. Still, we have no representation in this case, even though our children are the ones paying the highest price for all of it. I was told by someone in the law department that they did not represent us. They represent the county. While technically that is correct, we still elected the officials involved in this suit. Whether it be the law director or the BOE, all of you work for us. Watching what has played out over the last 5 months has been hard to see. Motion after motion denied. Our children are still masked. What is the answer? I can assure you, as many of you know, I have been in this since March of 2020. I have read more medical studies than I ever wish to see again. I have spoken to experts in the field and data analysts trying to make it make sense. It doesn't. It never has. Why has the BOE been denied outside counsel? After reading a letter, it is clear that the law department has a direct conflict of interest. Representing both the health department and the BOE is a conflict, as they are on opposite sides of this issue. Citing the CDC, AAP, and TDOH, and stating that masks are 80% effective should give all of you pause and force you to act, especially since Dr. Nguyen on CNN said that cloth masks are no more than facial decorations. I have been able to come up with many experts and studies showing what masks are doing to children. Why am I able to do this and not the law department? This is not my job. Maybe it should be. With all of that said, the most glaring words in all of this came from Judge Greer himself. In the order to mask our children in schools, he said, the Knox County BOE, which we know is represented by the law department, so their words were not used, does not cite this 3-factor test or conduct an analysis under all of its factors, and its failure to do so is by itself fatal to its argument that plaintiffs claimed are not ripe. Issues averted to in a perfunctory manner, unaccompanied by some effort at developed argumentation, are deemed waived. It is not sufficient for a party to mention a possible argument in the most skeletal way, leaving the court to put bones to flesh. Why were experts not brought into court? There are many. Why no teachers or parents or students? Masks are not without harm, and people are not accommodations. Never has ADA law been used in this way. The Board of Education needs outside counsel. 5 months have passed, and our children are suffering further learning loss, developing more mental health issues, while everyone else in Knox County is allowed to live their best lives. It is past time. I hope that you will support a resolution to allow the BOE to retain outside counsel and stand for everyone in the district, especially our children. Thank you.
Thank you, Ms. Gothard. Sherry Garrett. Evening, Ms. Garrett. If you'll state your name and county of residence, you have 5 minutes to address the
Sherry
commission.
Garrett, and I live in Knox County. Ms. Gerther spoke a lot of what I had to say too. It's very emotional. Our children are suffering right now. Their learning loss they have already suffered in the year 2020 is now being expounded on by the year 2021. The kids are suffering. And the only obvious course right now is to allow the Board of Education to have outside expert counsel. Our law department has been woefully inadequate in representing the school board and the parents, because the parents and the children are the ones that are suffering the most. They're the ones directly involved in this lawsuit. They're the ones directly affected. So I ask you, please, allow the Board of Education to hire outside counsel that can specialize in what needs to be specialized in, the ADA. As Ms. Gerther said, never have people been used as accommodations. The ADA was created to prevent physical barriers. That's why you see braille letters on the elevators. That's why you see wheelchair ramps going up into buildings. Invisible barriers were never, ever to be used in the ADA. Thank you.
Thank you, Ms. Garrett. Mayor Jacobs? Good evening, Mayor.
Thank you, Mr. Chairman. Appreciate the time. Glenn Jacobs, Knox County Mayor, 400 Main Street, Knoxville, Tennessee. From the beginning, I've taken an interest in this case, not only because, of course, the folks, parents of children in Knox County schools, our constituents, as well as many of the administrators and teachers as well, but because this case is about more than Knox County schools. If we go by the logic of this order, essentially any Knox County building, really any public building, could also be subject to the same terms. And I would like to read from the order. This is page 11 of the initial injunction. And it reads, in arriving at an answer to the question of whether a plaintiff is really seeking relief for the denial of a free, appropriate public education, FAPE, the Supreme Court has instructed courts to ask a pair of hypothetical questions. First, could the plaintiff have brought essentially the same claim if the alleged conduct had occurred at a public facility that was not a school, say a public theater or library? And second, could an adult at the school, say an employee or visitor, have pressed essentially the same grievance? When the answer to those questions is yes, a complaint that does not expressly allege the denial of a free, appropriate public education is also unlikely to be true about that subject. After all, in those situations, there is no FAPE obligation, and yet the same basic suit could go forward. But when the answer is no, then the complaint probably does concern a FAPE, even if it does not explicitly say yes. In the plaintiff's case, this case, the answer to both hypothetical questions is yes. The crux of the plaintiff's allegations is safe access to public brick and mortar government buildings, and not the denial of a free, appropriate public education. And it goes on to say, I'm skipping a little bit, a medically compromised teacher, custodian, parent, grandparent, or visitor could bring an identical grievance in this case, whether based on safe and equal access to Knox County schools or to another public government building like a library or post office. So as long as this case goes on, Knox County is under threat of this same order. If someone were to decide that Knox County should have a mandate in the city county buildings, our library, or any place else. And I guarantee you that I would be requesting from the law department to find the very best and brightest to fight that case. It's nothing against the law department. I have a great deal of respect for Director Book. I think he's a really fine man and has some great lawyers. They don't have the bandwidth for something like this, frankly, and the expertise. You just need the best that you can find. And we do that in other areas as well. The county just decided to hire some consultants for our comprehensive plan because planning doesn't have the bandwidth to handle that. Likewise, we have a transportation plan. We hired consultants because Public Works and our engineering Public Works does not have the bandwidth to handle that. And from my perspective, that's all we're asking here, is just some help. Because, again, I'm not going to go into all the stuff about masks, but, this is reached a point to where we need some sort of resolution. And again, the longer that it stays on the books, the longer this is enforced, the greater the threat that someone could sue the county and say, Knox County have to do the same thing. So thank you for your time. Very much appreciate it.
Thank you, Mayor Jacobs. This concludes public forum for tonight's work session. Madam Clerk, could you please read the caption on Resolution R-22-2-111 from Commissioner Smith?
This is a resolution of the Commission of Knox County, Tennessee, accepting the resignation of James Corcoran, District 3, on the Knox County Board of Zoning Appeals and appointing James D. Lloyd to complete the unfulfilled term of Mr. Corcoran on the Board of Zoning Appeals, which term expires September the 30th, 2022.
Chair will entertain a motion.
Motion to approve.
Second.
I have a motion to approve by Commissioner Smith with a second by Commissioner Ward. Any discussion? All in favor? Please say aye. Any opposed? That item passes. Madam Clerk, would you please read the caption on the next resolution requested by Commissioner Beeler?
This is a resolution of the Commission of Knox County, Tennessee, directing the Knox County Law Director to hire expert outside counsel to represent the Knox County Board of Education in all litigation regarding mask mandates.
Thank you, Madam Clerk. Is there a motion on this resolution?
Motion to approve.
Second.
Mr. Chairman, wouldn't we have to move forward since we
I
just
would-
got it 5 minutes before the meeting started?
I would just suggest that we send this forward with no recommendation, since we just received it, and I'm already seeing a couple of words that probably need to be changed in this.
I'll change my motion.
Is the second okay with that? Okay, I have a motion to send this forward with no recommendation by Commissioner Ward with a second by Commissioner Hill. Any discussion? Mr. J.
Thank you, Mr. Chairman. This action, obviously, sort of chain reaction of this started obviously with the school board. We've all been given information about the sort of back and forth, but I feel like we need to hear from our school board, and we need to also give our law director an opportunity to address the issue, just so we're fully vetting it. So I'm not sure, Ms. Henderson, Ms. Christie, or maybe both, I'm not sure. I just feel like they're asking us to do something. We ought to hear from them to kind of get the ball rolling here on the discussion.
Thank you, Commissioner J. I will state it this way. I, of course, was copied on a memo that was sent to the law director by Chairman Christie and Ms. Henderson. Subsequently, Chairman Christie emailed me requesting that a resolution, or asking if I would be willing to add a resolution authorizing the board to hire outside counsel. I said if a resolution comes to me before the work session, I'll be more than happy to add it. As I'm sure my colleagues know, it came to us about 3 minutes before the work session. However, Chairperson Christie, you are more than welcome to address the County Commission on this issue as well.
Yeah, thank you, Chairman Beeler, Commissioners. Christy, 2337 Winters Drive, Knox County. And like I requested to you, Chairman Beeler, in my email, and just to reiterate what the mayor said, I do respect the amount of time and effort the law department has put into this case. But, we have 60,000 kids and 8,000 employees, or probably more than 8,000, that are affected by this, by, universal masking because of 4 plaintiffs. And, it does concern me that a reasonable accommodation for 4 people could affect 68,000 people. You know, as a mother of a child that had a speech impairment and some developmental issues growing up, I know that she would not be doing well with the mask right now. You know, we have 3,358 kids that receive speech therapy in Knox County schools. 2 of those children have mask exemptions. You know, that's protected under the ADA too. So, you know, I think that our children deserve, you know, we need to be fighting for them. And, you know, again, I respect the time and that the law department has put into this, but I do think that it's time we seek outside help. And Ms. Henderson has a lot more notes because I drove back from Nashville today, so we'll just let her go from there.
Thank you, Chairman Christie. Ms. Henderson, if you'll state your name and address, you may address the
Thank you,
commission.
Chairman Beeler and Commission. Betsy Henderson, 12301 Connor Springs Lane, Knoxville, Tennessee. And I also have the pleasure of serving on the Knox County School Board. You know, I just think it's time that we seek outside counsel on this. You know, oftentimes we talk about running government like a business, and no business relies on one attorney. No attorney has the wide scope of every area, and we need outside counsel for this. The law department hasn't presented any medical experts or additional facts. They keep filing the same case that keeps losing, and who's losing out are our children. This case is affecting 60,000 children. It's affecting 8,000 staff members and parents. I know that outside counsel has been sought for the Merit Council cases, and this is the most prominent case in our county going on right now. We have so many areas, blue areas opening up, lifting mandates, and Knox County is still under a mandate for our students. It's time for a change, and I think we need real expert attorneys to handle this case. Thank you.
Thank you, Ms. Henderson. Any further questions or discussion from the commission?
Commissioner Jay, didn't you have 2 points that you wanted to just?
I just wanted to know if our law director, I have a specific law question, but I just didn't know if you wanted to opine on the matter of hand. I mean, we're voting on something that's affecting his department.
Well, I just got this thing, that nobody had the courtesy to bring this to my office until it was handed to me 5 minutes before this meeting. So I'm still trying to look at it and figure it out. I can tell you right now there's some problems with it. I don't have a problem if the school board wants to hire somebody to help advise us in going forward with this lawsuit. Because we are in charge of this lawsuit under the charter. We are the attorneys of record. We're the ones that are in front of the Sixth Circuit. We're the ones answering to Judge Greer. A couple other points. It seems to me that there seems to be this feeling out there that, oh, we'll just get another attorney that's got some ADA experience, and bingo, everything will go away, and Judge Greer will change his mind. I got news for you. That opinion, they read from several pages of that opinion. It's 56 pages long, and there's one conclusion in there that you got to look at. Judge Greer feels that if one child is running the risk, one child, then he feels it's his duty to order this mandate. Now, the proof is a doctor for this child is in there and said this child is going to be hurt if you don't have masks. How are we going to overcome that? You can say, okay, well, and in fact, in Tennessee, in Memphis, in Nashville, and Chattanooga, they all have mask mandates. And the federal courts have routinely said, no, you cannot do a no mask mandate. That's all across this state. That's in the Fifth Circuit. That's in Florida. And so what do? I agree with everything, absolutely everything I heard tonight at Public Forum. I agree with that. I agree that 60,000 students should not be held up because of 2 students. I agree with that 100%. I agree that a federal judge should not have authority to make policy, but that's what it is. He's God. He's got control. And I don't think bringing somebody else in, and if they want to bring somebody in to help advise us, I don't have a problem with that. This resolution, I haven't really had time to look at it. Part of it on the whereas, if the school board wants to hire some people to help advise us, we're welcome to that. We're open to that. But we represent, by the charter, we, the school board, or the law director represents the school board in this lawsuit. We believe in the school board's position. We believe in the parents' position, and we're fighting like the dickens for it. But we've got a federal judiciary that wants to go its own way. And how you set that aside, I don't think it's going to be easily set aside by Judge Greer at this point. And you talk about throwing in evidence. He had to set a hearing. We can't put in any expert testimony until he sets a hearing. He hasn't done that. He has shown no inclination to have an evidentiary hearing. The Sixth Circuit operates on its own calendar. We've got an appeal up there. I think it's an excellent appeal. I think we ought to win that appeal. But until the Sixth Circuit says you're going to have a date for a hearing, we can't do that. We can't make the Sixth Circuit hear us. We can't make Judge Greer set a hearing date for evidentiary hearing. I have no problem with anybody else coming in if the school board wants to hire them, but they cannot litigate this case. There's probably the legal question you were going to ask me. I think the whereas clauses, most of them are okay, but therefore be it resolved, Knox County Commission hereby directs the Knox County Law Director on behalf of the Board of Education to hire an attorney to advise and represent them in all matters. Commission, under the charter, has no authority to order the law director to do that. We're open, if the school board decides they want to hire an attorney to help us, we're open to that. But that resolution, you can't do that. It's not in the charter. You cannot order the law director what he must do. And I haven't had a time since I just got this thing to really look at it and evaluate it all. But those are mine. But I agree with everything that was said tonight. 100% agree with it. I do not like legislation from the bench. That's what we've got. We've got judges legislating from the bench.
Director, but can you just clarify, because there's been some back and forth about the sort of who has the power to do what. I pulled the Knox County Charter, which seems pretty clear about the law director. And I'm going to just take snippets of Section D here that says that their role and responsibility is to execute and administer all the legal affairs of the county. And then it has a very specific paragraph here or a sentence that says, no elected or appointed officer or employee of the county shall employ any other attorney to represent the county or any other officer, board, or member of the commission unless she shall first be authorized and empowered to do so by resolution of the commission. That's what's before us. But could you also just clarify, I pulled the Tennessee code. This is 49.2.203. These are the duties and the powers of the Board of Education. And it is quite lengthy, but there is on section, make sure I get this right. This is 15B5. It says the local Board of Education has the power to employ legal counsel to advise or represent the board. So Tennessee state law says they can already do that. Our charter says they can't do it without permission from us, which is what's before us. But are those conflicting, or which supersedes the other?
Two things. Number one, that's been litigated. Number two, at the time of the passage of that, it stated there's an exemption in there for any municipality or county that has its own attorney. That specifically says this doesn't apply to that. That's when that was passed.
Okay.
And that's what the legislative history showed. Secondly, the question has already been litigated. It cost the taxpayers $286,000 back in 2000 through 2003. The school board wanted its own attorney based on that statute. Mike Moyers, former law director, former chancellor, who is now back in our office, was there then, and he handled that lawsuit. He knows that lawsuit in and out. Bottom line was Sharon Bell, after much litigation, held as the chancellor, look, yes, that's what it says, but under the charter, which takes precedence, the law director is the one who represents the school board. That was then taken on appeal by the school board. And before the Court of Appeals ruled, everything I got from that massive file was that the lawyer for the school board saw after argument before the Court of Appeals that he's going to lose it. So they got together and they came up with a consent agreement. And that agreement says that the law director represents the school board. And the only time that it wouldn't is if there is a conflict of interest as defined by the Board of Professional Responsibility. And at that point, and that point only, can the school board get its own attorney. And somebody said there's a conflict because we represent the health department. Let's get something clear here. What the proof that they want, we have the CDC, the Tennessee Department of Health, and I put in that memo, go straight to that site, and it talks about masking being necessary and helpful in providing transmission of this disease. And our Knox County Health Board, the same thing. Now, you want me, people want me to go in front of a Judge Greer, who's already taken one expert and said it does, and take those, and I would be laughed out of court if I did that right now. Because he would say, well, by your own health department, masks are necessary. By your own Department of Health, the state. By your own Department of Education. I mean, that you got to have something more than just a desire to do it and have one expert. And here's the other thing. Judges weigh experts. He can accept one expert or just reject an expert. I mean, we don't know. Judges do that. There's no guarantee of anything on that.
I have just two quick questions for somebody from the school board.
Larson, can I
Yes, sir.
ask a question of the law director on
Yeah,
what
go
I
ahead. Just come back.
The CDC, the health board, those are recommendations. We're talking about enforcement
You're talking what?
mandates. The CDC, the health board, they make recommendations of face masks. They don't say schools should mandate face masks.
No, but that's proof that the judge looks at. The other proof that the judge has right now is the peak. We have peaked. We have peaked. How do you go in front of a judge and say, oh, well, you know, it keeps going up, school's going up? That's the kind of proof that a judge looks at. And a judge will look at what the CDC says, even though you're right, it's a recommendation. But he will look at it. I don't agree with those recommendations. But that's what they are, and that's what this judge is going to look at.
Can I ask one other question on something? You said that in the, I don't even know what you call it, that shows you what I know about law, summary, his ruling, that it boiled down to one line where one of the doctors said that one child was unsafe?
Yeah.
How does that require a mandate in a totally different school building?
I agree with you, and I have raised that issue. It has been raised twice in front of Judge Greer, and it's being raised very eloquently by David Sanders in the appeal in the Sixth Circuit. I agree with that. He flat didn't look at the effect it would have, which he has to do under law. He did not look at the effect on third parties, the other 60,000. He didn't do it. And we've appealed that. We've said, you're wrong, Judge. You can't do that. The other thing I wanted to bring up is, this is brought by two of the members of the Board of Education. I want you to know this has not been authorized. What they've done has not been authorized by the Board of Education. They have not passed any resolution seeking that. This is two members of the board. In fact, at the last meeting on February 9th, a motion was made to allow the department to continue, the law department, now that they have heard all of the board's thoughts, to do everything they feel is possible as quickly as they can that does not violate rules or jeopardize the case. That's the official act of the Board of Education, not the request that two members are making here. That is not the Board of Education's request.
Commissioner Jay, you have some questions for
Yes.
the school board members?
I have three questions. I just added one, sorry.
Can Susan speak to that last?
Well, let me tell you my three questions, and you guys can figure out who wants to take them. There's three of you, maybe you all each get one. My first question is going to be, why didn't the board vote unilaterally to ask us to do the action that is before us? My second question is, to clarify, are you asking to hire outside counsel to advise the existing case and the law department, or to take it over and ask them to step aside? And then my third question is, besides the taxpayers who pay for everything, who's going to pay for this? Are you asking us to appropriate funds, or would you cover the expense in your budget? So those are my three questions, and take them as you will. Let's start with the first one.
I didn't make a motion at the this is Betsy Henderson with the Knox County School Board. I didn't make a motion at the last school board meeting. I did have a letter that did not make it around to all the school board members that evening, and according to the county charter, the action is up to county commission. They don't need a vote from the school board. So I said that I was going to take this in front of county commission either way. And I would like to, can I address some of the things that Mr. Buick said? Is that possible?
If you could answer my questions first, and then I'll
Sure,
kind of
sure.
let it go back.
Yeah.
So that's the first. So I guess this body, I guess the question would be, are you all acting on behalf of the whole school board, or what if one person just asked us to do something? I mean,
I think we're looking to as a school board to have the power to make that decision.
Okay.
So that we have the authorization to have outside counsel.
So if this body were to approve this, you would all still go back and vote on it within your governing body to whether to take action on that or not?
Correct.
Okay, all right. So
Correct.
thank you. So the second question is, are you asking permission, I hate to say that, but are you asking us to authorize the hiring of outside counsel to advise and to sort of attach themselves to the case, or advise the law department in a very specialized way, or to take it over and have them walk away?
I would like to see somebody take it over, to be honest. I've been and I think several board members, parents in Knox County are very disappointed in how this case has been handled. Mr. Buick tonight didn't even know a lot of the facts that were going on in this specific case.
How would that work, given that our charter says that the law department is the lawyer for the county? There's not a lot of wiggle room in that interpretation.
Well, in the charter, it says that the county commission has the authorization to grant another body outside counsel.
Okay. And my last question, and I feel like that piece of the onion is going to be peeled back, and I won't get into that. I'll let somebody else discuss it. Who would pay for this? The taxpayers will pay for it, but whose budget will it come out of?
To my understanding, the law department has money to seek outside counsel, and Mr. Buick has the plaintiff's already asking for $250,000, and that was in January. So he's already cost us $250,000. If he had just asked for outside counsel and admitted that this was out of his scope months ago.
So this would come out of the county general budget, which
Out of the
includes
budget that is already allotted for this.
Okay, not out of the school board budget.
If we needed to work with the school board, I don't know if Ron wants to speak to that.
Ron is going to run away very fast.
But to my understanding, there is money currently in the law department's budget.
Okay, so you would be asking for an appropriation from the law
Correct.
department's budget. Okay, thank you very much. I'll yield.
Thank you, Commissioner Jay. I will say this, and I appreciate your questions, because I need, as the chairman who agreed to sponsor this resolution on behalf of the school board chair, I'm not comfortable with directing the school board to do anything from this body. What I am comfortable with is any mechanism that is allowed under the charter by which commission could grant another elected body the authority to take this type of action on their own. So that's why this resolution needs to be looked at before we take any further action on it. Commissioner Schoonmaker, light is on, sir.
Thank you, Mr. Chairman. There's a couple of, I guess, background information that I'd like the answers to, and I guess this would be directed to the Law Director Boog. Currently, for the federal case out of Greene County, how many members of your staff, or what is the legal team that's working on that?
8 out of our 10 lawyers.
Okay, are they?
Day in, day out. Every day we meet on this. We have researched every case that's come down, what's happening in other jurisdictions. So yes, it's a day-to-day thing for 8 attorneys.
Okay, and then currently you referenced that there's 3 other counties in Tennessee that have mask mandates besides us, so it's a total of 4 out of.
Yeah, they have their own mask mandates. They have not been imposed by the feds or by a federal district court. But what happened is in Memphis and Nashville and Chattanooga, I forgot to check on Kingsport up there, they have imposed their own mask mandates as our school board did last year. They had a mask mandate of their own, then they got rid of it. So those other schools in the other districts are not under a lawsuit. But what happened was the governor passed the statute, as you all know, that provided that you couldn't force mask mandates. That statute was passed, and immediately in the Middle District of Tennessee, they went to the federal district court, and that federal district court put an injunction against the governor from executing and administering that law. So no matter what happens, that law doesn't have effect anymore until that's heard before the Sixth Circuit. It's a complex mixing of things that are going on. But the mask mandates for children, and you know, we keep up with all of this stuff. And by the way, I don't know, nobody has given a reason why our department, which deals with and has dealt with ADA daily, our lawsuits with ADA, I've been in this office for 10, 12, almost 12 years now. It's a daily thing with ADA lawsuits. We have the best experts there are in ADA. I have yet to hear anybody explain why. They just think that if we get another attorney, boom, it'll all go away.
Okay. And then one of the speakers gave a date of September 24th of this past year. That was the date that the ruling was issued by the judge or thereabouts?
No, it was,
Because what my follow-up question to that is then how many actual hearings has he had in Greene County where your team has gone up there?
we've been up there for, here's what happened. We got served mid-afternoon on a Friday, September 10th. Mid-afternoon on a Friday. The judge sent us a notice that he was going to have a hearing on the 15th. We got 2 weekend days. We've got 2 working days to try to get something together that the plaintiffs had been working on. Obviously, they had their experts, they had everything. We raised that issue with the judge, said this is an ambush. The judge said, well, that's the nature of injunctions. It's just the way it is. So that's the situation we were in, and that was kind of the mindset that this judge had and still seems to have. So, and I forgot what your question was.
How many times have we had to appear before this judge since they issued that original?
Twice. That's all he has ordered us. We were there when we filed the motion to lift the injunction. We were up there and asked him to modify his order and gave every reason that I've heard out here to the judge. He ignored every bit of it and said, no, denied. And that's when we took it up to the Sixth Circuit on appeal. And we've got an excellent chance of winning, depending on which panel we get up there, on winning at the Sixth Circuit. But we have no control over their docket. I wanted to throw something else in, I didn't too. one of the motions that was passed by the Board of Education was a motion to have the Knox County Law, this is the kind of, they're putting their trust in us. The majority is, several aren't, but at any rate, this motion was to approve Knox County Law Department to engage in non-binding negotiations over the mask mandate litigation within the parameters of state law with the Board of Education, represented by Board Chair Christy Christie, Knox County School Staff Representative Jason Myers, and we have already opened that door with opposing counsel. So we are engaging. We're doing what the board has asked us to do. We have engaged in trying to come to a negotiation with a settlement, a mediation, whatever you want to call it, with the other side. So, and we will continue to do that no matter what this body passes or, so at any rate, I just wanted you to know we're doing exactly what the board's voted to do.
Okay. And, Mr. Chairman, I had noticed that school board member Susan Horn had come to the podium, and I wanted to give her the opportunity if she wanted to make a statement to us, or since she is my school board member.
Very well. Ms. Horn, if you'll.
And very well respected in our community.
Yes, sir. Thank you, Commissioner. If you'll state your name and address for us, Ms. Horn.
Thank you, Commissioner Schoonmaker. Susan Horn, Knox County. Well, I wanted to say that the letter that that Board Member Henderson passed around, I wasn't able to see it, and I think that but I knew that her intention was to bring it before this body so that then it could be offered up to the Board of Education. I think that part of our frustration is that there are studies that talk about mask efficacy and that things have changed drastically in the past 6 months since September 24th or since September 10th when this was served. So that is another issue that I think obviously this revolves around the ADA, but we're very concerned that there's no new that it doesn't appear that the law department wants to look at any new medical evidence, and there is new medical evidence, and it's very important in this case. And I think that's part of why, even as around the country, as mask mandates are being lifted, there are still lots of cases of COVID. However, at the same time, new evidence is coming out and evolving, and that's what happens with science, and we can't ignore that. And I think by ignoring that, that's a huge disservice to the students of Knox County. Our highest goal is to make sure that the students of Knox County are educated, that they are progressing. I hear from kindergarten, first grade teachers, second grade teachers who are extremely concerned because students are not developing as they should at this age as they're learning to read because they can't see their teacher's mouth. Ms. Christie already mentioned students with special needs, with speech delays. We are extremely concerned about these students. This is our highest goal, is to make sure that students are educated and developing as they ought to be. And at every turn, that's being impeded. So our board is, we talked about this subject at length last week because we just feel a sense of urgency. We need help. We need something to move and change in this case. And so that's why we spent the time last week. That's why there were several motions. So that's just kind of where we are. And we continue to feel a sense of urgency from our communities, and some more than others. As Commissioner Schoonmaker knows, our end of town is extremely upset and concerned about this. So that's why we're here. Thank you. I appreciate the time.
Thank you, Board Member Horn. Commissioner Biggs, your light was on next.
Ms. Horn, I have a question for you, Representative Horn.
Yes.
You spoke about specific areas throughout the state of Tennessee. Have you all done any look into other states or anything like that border us, or Florida, or anything that might be happening down there? Are there lawsuits? Are there not lawsuits? In Florida or wherever? Have you looked?
I think there are some similar lawsuits around in Pennsylvania. I can't remember where the other one is. There's another one that's similar to this. And they all seem to be just a little bit different, which I think, from what I understand, makes a large difference in legal terms.
Did the state of Florida go through something like this already? Have they not done
No,
anything
they did
like
not.
this? So there's no case.
No, they have not that I know of, that I'm aware of.
Okay, thank you.
Thank you.
Commissioner Bustler.
Thank you, Mr. Chair. Your light was on, then it went off. Mr. Ward.
Yeah, I hit it twice. You can go before me. I'm not in a rush.
Okay. I think what we've got here is there's two different sciences working against each other. One of them is the science of health, the other one is the science of law. And they are completely polarized in what they do. Judges have a certain attitude. I hate to say this, I know some really good judges, and I know some judges that I wouldn't want even close to me, and how they rule things. So what we have here is we have a law department that has taken the appeal, and I think you've got it to another appeals court, Sixth Circuit Court. If you think government works slow, the courts work even slower, because they can drag things on forever and ever. And it sounds like we've got a judge that doesn't want to hear, doesn't want to understand, no matter who you bring before him. And if you keep bringing other people before that judge, you're going to make that judge even worse than what he is right now. So we've got to go through an appeal cycle. And again, you say the science is changing. But what's before the judge is what he's got before him. And I don't know how you get these other pieces of information to the judge. They either accept it or they won't accept it. Is that correct, Mr. Book?
I didn't catch the question.
I said, it's up to the judge to decide whether they're going to accept any new evidence or not have any new evidence, correct?
Absolutely. I mean, this is an injunction, and if it stays in effect, the judge will set a trial date.
Okay.
But he hasn't done that yet.
But he's got to set that trial date, and any other judge has to do that. And if you start now, you're going to start from the bottom again, and they're going to go back with the precedent that Judge Greer set in the next case. So we're in a rock and a hard place. We could throw a ton of money at this, but until the judge wants to move, he's not going to move. So we've got to decide, we're going to spend money, or we're going to see how far we can go with what we've got before us right now. And again, I'm for this. I hope we never had a mask in the first place, because they never did work. And I understand that. And we had a big problem up here when we were trying to talk to the health department about that. So we've been through that. So I don't know what we do here. I don't understand the law, and I don't understand the science sometimes. So I'm hoping the law will figure out a way to take care of the science. And with us just getting here batting before each other and throwing money at something that's not going to work, or other people, it just doesn't seem like it's going to work. So wherever we've got to right now, we just got to keep trudging forwards with what we've got before us and try to get it before a judge that will hear what you all want. So that was just what I was going to say.
Thank you, Commissioner Bustler. Commissioner Ward?
Thanks, sir. Chairman Beeler, I kind of agree with your assessment too. After getting this 3 minutes beforehand and reading through it, I do think this needs to be edited a little bit to give the Board of Education the power to make this decision, not us as a body. But and whether the board decides to use, if we do grant you this power to hire, whether you use it or not, I think at least the common ground from what Director Book is saying that he's comfortable with, and is to maybe hire at least an expert to counsel us a little bit better. I get super passionate about this. I know that the mayor and I have had several conversations, and we both get pretty fired up about this one. Like, the idea of suffocating 60,000 kids a day is just gets my blood pumping, basically, and gets me pretty upset. And I know if that was my kid, that I would want the Michael Jordan of lawyers on my side. I'd want the biggest, meanest bulldog in the yard on my side. So I 100% agree, and I definitely think that if we need to hire the Michael Jordan or the all-star team, whatever that means or how much money that takes, for our kids' safety and health and mental well-being, I don't think you can put a price on that personally. So I do think this needs to be adjusted, but just wanted to share my general opinion on the whole matter.
Thank you, Commissioner Ward. Director Buch, your light was on next.
I just wanted to clarify, number one, what Ms. Horn was saying. I agree with it 100%. I agree. I agree with everything that's been said tonight. The judge doesn't. And the comment was made about not keeping up with the medical, that's wrong. We know all of the medical things that there are out there right now, and there are all sorts of them, but you can't just come in and say, Judge, John Hopkins says this. That's hearsay evidence. It's not admissible. It's true, and we know about it. So it's wrong to say that we haven't kept up with all the medical things that are going on out there. We know all of them. It's just whether or not they're admissible or not. Number two, the Florida case, yes, in Florida, DeSantis, the governor, did exactly what our governor did. He said a no mask mandate, period. He did that. Immediately, that went to federal court, and it was turned down. So yes, something did happen in Florida, and Florida's under the same thing with regard to those mask mandates, and it's the federal courts are controlling down there also. And the other thing was, when you look at these things where people say mask mandates are going down, and they are. It's a political thing right now. The liberal states are finally dropping off because they're afraid of the midterm elections. But if you look at these, you will find that the school mask mandates in many of these jurisdictions are held in place, although generally, for the general public, the mask mandates are being lifted, but the schools are still under.
Thank you, Director Buch. Commissioner Hill, and then Smith, and then Jay.
Director Buch, I'm hearing that that Knox County Law Department, you believe, and it seems you're doing everything possible that you can do at this point. I'm a little bit interested in, you had kind of opened the door a little bit about some possibility of mediation or negotiation. Have any attorneys with the law department spoken directly with the plaintiff's attorney and made any attempt to perhaps negotiate with the, I don't know these parents. I don't know them at all. I'm really wondering if their intent was to put masks to 60,000 kids when they went into this whole thing, and maybe it was. I don't know, but the ramifications seem such that I'm wondering if there would be any hope of a settled.
Well, we're trying. We're doing exactly what the Board of Education has asked us to do. We're working on that.
So have you all reached out to
Yeah,
plaintiffs' attorneys and asked for a sit down?
We have. We get tricky on this sort of thing because we can go into executive session with the board and say, look, this is what has been offered, and here's where we are, and they can't make a decision on that because they can't vote in an executive session. They then have to come out and vote and say, okay, yeah, we want to go with what this mediated or negotiated settlement is. We're working on that. We're doing what the board wanted on that.
Okay, I'm familiar with the executive session.
Yeah, I know you are.
I know what you're talking about.
I sat through many of them with you.
Yes, you did. So just to be clear, there is active negotiation or active attempts at some mediation with plaintiffs' attorneys.
Absolutely. Let me tell you something else. I think I mentioned this to the board or something. From Susan Crabtree, who was probably the greatest expert in ADA law that's retired, that she taught Amanda and David Sanders in our office, and that's why I say they're the best. There's only one other that even matches them, and that's the lawyer that's representing these plaintiffs. He's the only lawyer in the state of Tennessee that handles these cases, except for us. So, but his attitude is, see, under ADA, he gets attorney's fees. He can get a minor thing just saying, oh, you got to do this, and he'll get $500,000 in attorney's fees. That's why he does it. He is a scorched earth type of lawyer. So we're dealing with that attitude, and I don't even know what he takes back to his client. We would take back to the school board if we get something that's they're willing to do. We would go to the school board in executive session and tell them about what it was. So yeah, we're doing that. I don't want to mess that up. Ms. Horn also made a motion that I appoint Houston Havasey in our office to assist Amanda Morris. Well, he already is. He's already helping because we operate with all the attorneys working on it. But if she would like, if the essence of that motion is to put his name down there on the list of attorneys, we'll do it. So we're doing everything that the board is authorized. And I'll stand by that, and we'll continue to do that. The negotiation is the most important one, I think, that was raised, and that was, I think Ms. Horn made that. No, that was Virginia Babb made that motion. But at any rate, I can't tell you any more than that. And then there's the legalities of kicking the law director out and hiring outside counsel. I don't want another lawsuit, but we will enforce the charter. Mike Moyers knows how to do it. He did it.
Would you please briefly address the comments that our mayor made about the concerns of this boilover spread to other public buildings that is really of a general concern to many of us?
That was what was brought up by plaintiff's counsel. I don't think it has any meaningful thing whatsoever. I mean, it's if you can take it to its extreme and say, okay, I'd got to go back and look, but that was almost a throw-off thing that the judge said in that 56-page opinion. I can't really address it because I don't have it in front of me, but that was just one little blurb out of that opinion that really had nothing to do with the opinion.
I might merely suggest that in the law director's communication with the board, and even if this has to occur in executive session, that they might be given a little bit more specifics and details about exactly what steps have been taken, what has been tried, what types of negotiation, mediation have been put out there to perhaps calm the school board waters, so to speak, so that they may feel a little more secure in the actions of the law department.
You are reading my mind. I have already set out, because there's so much misinformation out there, that I am, as we sit here, drafting a comprehensive report on how it got there, the status of it, what's happening, what happened in the future, as a public document, because I can't comment on the litigation under the federal rules. I can't do that. I can only lift out what's in the pleadings. But you've read my mind, and I'm in the process, and hope I'll have that out by the end of the week, a complete explanation of everything, where we're going, what we have in our arsenal, and I cannot predict when these judges are going to act. I just can't do that. And no matter who you get, add-on or whatever, it's up to the judges.
Thank you, Commissioner Hill. Commissioner Smith, your light is next.
Thank you, Mr. Chair. Mr. Law Director, can the Board of Education and Law Director not countersue the plans on the grounds they are harming our students and our educational process?
Under what theory?
Well, I don't know, you're the lawyer. I'm just asking the question.
No, because if the minute you do that, if you say it's an ADA issue, they're not disabled students.
Well, I'm not
The
saying.
60,000 aren't disabled.
There are disabled students.
Gallery, please be in order. Thank you.
There's 800, I think, that are under IDEA, I think, students in the system. There have-
I'm talking about the normal system, the first grader who's trying to learn phonics, that can't because a mask is on. The
That
teachers-
argument has been made. We have made that argument. That argument is before the Sixth Circuit. It was before Judge Greer. It got rejected out of hand by Judge Greer.
So you're saying you can't bring a countersuit against these plaintiffs?
Well, it wouldn't be a countersuit. It's just saying, Judge Greer, you can't do this. I mean, what's the countersuit if he says, he's already said, look, you can't do that. It'd have to be it's not a countersuit. You'd have to bring a separate complaint, but it's really a defense under the rules. I mean, that's, I guess if somebody wanted to file one, if somebody out here wanted to file one, they could do it.
Okay, you had mentioned Susan Crabtree. Has your office thought of bringing her in to help?
Yeah, I wanted to bring her back. I did. She's retired, but she is very happy in retirement. She has a grandson that she takes care of twice a day. Sweetest person in the world. And, yeah, she's not interested in coming back to work.
Okay, and in all the, and I know, and I'll say this, I work daily with the law department, and they are really good at what they do. I work with several of the attorneys almost on a daily basis, so I do know they are good at what they do. Now, I do know this is something outside normal day-to-day operations. Can you ever think of an example where an ADA compliance imposed upon someone else's body, something they had to do?
This is absolutely new, and it's the only one, and it's brought about by COVID. And the judge has put himself in and saying what he said in his opinion. That's what he said. No, there's no other time that it's been done. And we pointed that out to the judge. This doesn't apply. You can't use ADA in this case. But the judge rejected that. Twice we said that. And now it's up to the Sixth Circuit Court of Appeals, the same argument. I agree with you. I agree with you.
So if the CDC, the Knox County Health Department, if everywhere they said masks are no longer required, we would still be under this until we get a trial day.
We would still be under it. We have been asked by the Board of Education, let's see here. It was by Ms. Horn. She had a motion which was passed, wanting us to file, and what she said was, file a change of circumstances, which is not a motion that is applicable. I mean, it's not. But we're good doing that. And it says that references that vaccines are available to everyone in Knox County, school buildings, that mask mandates are being lifted all over the country, that masks protect the wearer, and any other information. So we're working on that. We're doing what motion that Ms. Horn, we're working on that right now. But here's the timing. If you look at what's going to happen, right now we're still peaked up there, but it's dropping. It's got to get down to get this judge's attention on anything. And then what's Joe Biden going to say on March 1st? Because he's got all these Democrats saying lift the mask mandate. Is he going to say pandemic's over? So, but we're working on that as we speak.
Okay, I don't want to find ourselves trapped, stuck in a pandemic when it seems like we are moving out of this, and we have actually peaked and coming down here.
No question, no question.
But, and I also am very wary of what the mayor said, as Commissioner Hill commented to, that somebody could go anywhere right now into one of our libraries or into this building and get the same ruling from this injunction.
That's a possibility, and we raised that issue that you can't do that, Judge. But if somebody wants to file over here in the library with children that are, or have disabilities of some sort, and go in front of Judge Greer, they're probably gonna get that same ruling, and it's wrong. It's just wrong, legally. It's not just legally, but it's just wrong, period.
Thank you, sir.
Thank you, Commissioner Smith. Commissioner Jay?
Thank you, Mr. Chairman. As you revisit this, I mean, this is being moved forward with no recommendation next week, and as you have already opined that, you know, there's some language that may need some tweaking, I would like to ask for your consideration. I would be more, I would be open to this, a couple of amendments to this specifying that if the action was, you know, if the authority is granted, if the action to be to advise, because I don't believe, according to our charter, you could replace. I don't think the school board can unilaterally replace the law director from the suit. So I think that somehow needs to be outlined in there. And then I would also be more comfortable with adding some language to specify that if they did choose to act with our authority and hire outside counsel, that it must be paid for out of the school board budget. If they're going to direct the action, if they're going to pick the lawyer, if that's outside of the decision-making power of the law department, certainly can't then therefore require a certain amount of money out of a budget of a department that's already been approved last year for the entire year. So if they're going to take that action, it needs to come out of their budget. And their budget is our budget, and it's the Knox County taxpayer budget, but you can't, I don't think you can direct action and then tell somebody else what to pay for, kind of thing. So I just would recommend you those two things you at least consider when you look at the language amendments. Thank you.
Thank you, Commissioner. Point well taken. Commissioner Schoonmaker, you're next, and I will give the maker of the motion the last word on this.
Thank you, Mr. Chairman. What would happen if the superintendent of Knox County Schools said, beginning tomorrow morning, our children would not wear masks? What would happen?
Director Book?
I would imagine that Justin Gilbert, the attorney, would immediately be filing a motion for contempt and haul the superintendent in front of him and hold him in contempt, for which he could throw him in jail, he could fine him, he could do a lot of things, because he would be in contempt of that order.
But you'd have a hearing before the judge.
But only on the contempt. Only on the contempt issue. Contempt, because this is an injunction at this point, and it's only on whether you violated the injunction. That would be the sole issue.
I just thought if you got another chance in front of the judge.
I would love to find another chance to get this judge, as indicated he doesn't want to hear the proof at this point.
Thank you, Commissioner. Commissioner Ward?
One last question, and then from what I hear you saying, that you don't think there's any path forward with this judge in particular, are we putting all our eggs in the basket of the appeal court? That's what it sounds like you're saying.
Well, two answers. Number one, as was the motion that was made at the Board of Education, which we're pursuing, is if everything goes down, it drops drastically and it goes down to nothing. And the board and our local Board of Health, and they'll follow CDC, and if the feds, the CDC back off, then we've got a change of circumstances that are facts that we can go in front of the judge. So yeah, that would be good if we could do that. Other than that, yes, we're pinning our hopes on the Sixth Circuit Court of Appeals just to lift the injunction. If the injunction is lifted, then the case will go forward on, and I think we would win the case on the facts if we could go forward.
So I think from hearing from everybody at this point, we need to make some adjustments to this document before it's passable, or before we can get everybody to agree on it. So, Chairman, if you give me some advice, what's the best way to handle? We probably need to edit this before we go and vote on it next week. Do I need to amend my motion or anything of that nature?
I don't think the motion needs to be amended. I think the motion is just to move this forward with no
Forward.
recommendation.
And
It's
then
not
we'll-
like an ordinance that we're passing
Under-
in first reading, so.
Okay, so under the understanding that we're going to make some edits to this and it'll look slightly different to next week when we
Yes.
can have a further discussion on this.
Yes.
Okay, so given that, before we wrap up, I think we're got one more light on after me. Does anybody from the school board have any other comments they'd like to make before we kind of move past this and make a vote?
Thank you, Commissioner. If you want to yield to Ms. Christie, that's fine.
Just a few remarks based on what I heard. The negotiations, that motion that was passed at the school board meeting last week was to allow myself and Jason Myers to negotiate with the plaintiffs. Of course, any agreements we came to would have to come back to the full board for a vote. But being involved in those, I don't want to give anybody any false expectations that, we're going to come back next week and say, yay, no masks, because I'm not that optimistic from where I'm standing or what I've seen in that. Also, as far as someone asked about suing on behalf of the other kids, and the comment was made that those children don't have disabilities. That is not true. And since the last meeting, and I raised the concerns about the kids with speech impairments, which are covered under ADA, I have been getting countless emails and phone calls of people just pleading, please advocate for my child's disability, because they're not getting an exemption either. So to say that we don't have children out there with disabilities that this is not having a negative impact on is not true. Absolutely not true. And as far as cost, I've talked to Mr. McPherson, and I think, ultimately it's not just my decision to make, but it's worth it. But I would also like just to add the cost of additional lawsuits when these other children come and sue us. The cost of making up for what they're missing in the classroom, the cost of increased services to speech and other services that they're not getting or they're falling behind on as far as language development. There are lots of costs here that go far beyond paying for attorneys. And I think it's important for people to remember that. I mean, I don't see how we can afford not to pay for it at this point. And then as far as the mental health, the medical experts, yes, the CDC, the health department, we've heard those, but what about the mental health experts? They're medical experts too. What about the speech pathologists? They're medical experts too. What about the audiologists? There are all kinds of other medical experts that could speak to these other children that are not getting exempted. I mean, this is not a reasonable accommodation for them. It's hurting a lot of other kids, and it's hurting staff, and it's also creating a burden on the system. I mean, we're losing staff members. We have teachers in South Knoxville, and Carson, I know you've heard this too, that say, if we end this year with masks, they will be going somewhere else next year. We're just desperate. We need help. So, and thank you for allowing me to speak.
Thank you.
If I could, every one of those arguments I agree with. I agree with Ms. Christie's, what she said, and we have made those arguments to the judge and in the Sixth Circuit.
Ms. Henderson.
Thank you, Chairman Beeler. What I hear tonight is, Mr. Buke, you don't even know some of the facts of your own case. Knox County peaked on January 18th, so we are well past the peak. You mentioned that we have maybe 800 under ADA, more like 8,000 under ADA that this is affecting. How many times have you spoken to the plaintiffs? How many medical experts have you spoken to since September 1st? I know you can't bring articles and newspaper articles to court because it's hearsay, but in my presentation last week, when I did bring those articles, I then contacted all of the infectious disease experts who wrote those, Harvard-educated doctors, and 4 of them got back to me. 4 of them. You spoke to Susan's change of circumstance. It took you 5 months to do that. This is the most important case going on in Knox County right now. The most important case, and you don't even know the basic facts of what's going on in it.
Commissioner Biggs.
Thank you, Chairman Beeler. Multiple times tonight, we've heard change of circumstance. And I was up here looking at some stuff on my phone about when Judge Greer was talking about this decision, and it looks like this decision is based off the Delta variant, and we're on the Omicron now. Is that, given the science and everything that goes into that, is that considered a change of circumstance? Or?
He amended his, he had an original order, and then he's got one that's dealing with it now, his amended order. He had 2, the first one, and then when we called his attention to some of those things, he amended it. He denied us any relief, but he amended it, so now it's under, he's got that under consideration.
Also, I was wrapping around what Commissioner Ward said. I'm just wanting to see, is there any light at the end of the tunnel? What can we tell parents, the direction, and where we're at? Do we even know where we're at? Right now, it seems like we don't really know where we're at. If we're going to make a decision as a body to allow the possibility of the school board to have outside legal counsel, I would like to know all the instances. We just talked about Florida. We talked about some of our surrounding states, other counties. I would like to know, what can our next step forward be? Because I feel like right now, from the hundreds of emails that we've gotten, parents are starting to feel hopeless. And I don't like parents feeling that way whenever it comes down to their children. And 60,000 kids, and the lives we're impacting them. And like Chairman Beeler stated earlier, this has given the school board an opportunity to have outside legal counsel in the direction of this case, but at the exact same time, if this is implying just a shred of hope in the right direction, then I'm for that as well, just because I feel like it's our kids. And I saw something that broke my heart. Okay, everybody in here knows I have a little 4-year-old girl. When this started, the kids were in kindergarten. Now those kids are in 2nd grade. And I don't know Judge Greer. I do not know Judge Greer, but I could tell you from looking at this right now, this guy's going to push it to go through the end of the school year. So then what? Do we fight this over the summer and hopefully have some sort of amazing act that happens and we don't push it into next school year? And I'm here to say, I think all the help that we can provide, the law director's office, the county mayor, the school board, we fight this as a team because they're fighting us as a team. And I think Director Book's got some great points, but in my line of work, we do this thing and it's called all leads exhausted, not to be found in Knox County. Obviously that doesn't here, but I would like to see all leads exhausted and we charge back as much as we possibly can. And if that means outside counsel, then I understand that too. But I'm just worried. At the end of the day, I'm very worried about our students and our parents and the mental capacity that they have right now.
Thank you, Commissioner Biggs. Commissioner Smith. Your light is on, sir.
Yes, thank you, Mr. Chairman. I think one of the biggest things that's changed is vaccines. Kids 5 and up can now be vaccinated. But Law Director Booth, I had a question, and again, this is going to show my ignorance of the law. But do injunctions not sometimes, or can they contain sunsets or review dates, since they are usually on something that...
Only if the judge puts one in there.
Okay, do we ask for one?
We have to take it away totally. Here's what you might be thinking of. If you go in to get a restraining order without any proof or any evidentiary hearing, the judge can give one on affidavits, and it's good for 10 days. After that, he's got to have the hearing, which is what he had, a hearing that they obviously had prepared a month for at least, and we had 2 days to prepare for. That's the way it was, but no, there's no limit on it. That injunction could stay there forever.
It just seems kind of strange on something that's evolving and changing as a virus.
I agree 100%. I have not disagreed with anything I've heard tonight. I am in agreement, and we have fought that. We have represented those issues to the judge in the Sixth Circuit.
Thank you, sir.
Thank you, Commissioner Smith. Motion before us by Commissioner Ward with a second by Commissioner Hill is to send this forward with no recommendation. All in favor of doing that, please say aye.
Aye.
Any opposed? That motion carries. Madam Clerk, please read the next item.
This is item number 41, discussion item regarding redistricting updates.
Shifting gears, Commissioner Schoonmaker, you have the floor, sir.
Wow. Yeah, well, it's good we have a couple of school board members still here. But anyways, what I was looking at is because many of us have a lot of our territory being shifted from one commission district and one school board district over to another commission district, another school board district. And do we need to be working with our counterparts? As an example, I'm losing a big chunk of my territory to Commissioner Ward. So that if there is a issue that would be potentially ongoing past, September 1st, should Commissioner Ward be in on that decision if it's a stormwater issue or something not something that could be filling a pothole? And the same for our counterparts on school board. Should they be looking at, transitioning over to the next representative? Now, we all know that on May 3rd that people that normally would vote in the 5th district that are now in the 4th district will be going in and electing a school board member from the 4th district. However, theoretically, though, that territory doesn't transfer until the August 31st or after the election. So, but I just kind of want to put that out there because there is some confusion. There's a lot of people that don't realize that in my case, if they normally would go to AL lots to go vote, the word hasn't gotten out that now that's part of the 4th district. There is somebody running for school board in the 4th district, and they're going to need to be aware of that. So, in community meetings and things from now till the end of the summer, we need to just kind of reemphasize, hey, did you know this is going? Like your, 6th district is losing some to the 3rd district. And then, so those people are prepared because, people walking in for early voting can all of us say, well, hey, I normally vote in the 6th district. Nothing's going on there. Why am I now voting for a county commissioner in the 3rd district? So, but there's no standard across the state as far as how to handle that. So it'd be just up to how we want to handle it here, where something with the 1st district going to the 2nd, vice versa. So
I think you make a great point. And I think when the new terms start for the next set of officials, September 1st, everything will have then transitioned. But I think it's incumbent on all of us to really make sure which precincts have shifted out of our districts into our districts and which commissioner we currently share those with and communicate with.
Yeah. Well, and I did request that they do update the knoxcountydistricts.org, and they went ahead and updated and put the map that we approved. And then as you scroll down on the website, it's listing the 11 precincts that changed. So if you normally voted in Shannondale, now it goes from here to here, or Ball Camp Pike, or whatever it is. So Ball Camp Elementary. So,
Indeed.
Anyways.
No, thank you for bringing that to our attention.
You're
Is there any
welcome.
further business to come before this work session? Chair will entertain a motion to adjourn. We are adjourned. Reminder, our commission meeting is next Tuesday in the small assembly room, beginning with beer board at 4 p.m.